Whenever you're ready.
Ready.
Okay. All right, we're back. Now we're going to go through the problem set that's available on the website. If you're watching this video on YouTube, a link to where the problem set can be found is in the description of this problem set. We're going to go through these problems, and I want to note that I'm going to be posting explanations for these problems after we're done discussing the problem. Keep in mind the explanations are terse and don't really rise to the level what would be a sufficient essay. Also, as a preliminary, I'll point out that some of these problem set questions would make really good practice essay questions for you. So, just like with any of the other stuff, bring me the question, bring me 2 copies of your practice essay, and I'm happy to look at it right then and there and give you feedback. All right, the first 18 questions rely upon a fact pattern involving, I just made these two names up. There was Chandler and Joey. I don't know where I came up with those names. You know, what's funny is actually, Chandler and Joey starting to be really dated, isn't it? Dated a little bit, right? It's not like an old TV show now. It's been on for like 10 years. Should I redo the hypos?
No, they're on Netflix.
No?
Yeah.
Who should I use? You know, Walt and Jesse?
Betty Barney, Big Bang Theory.
Oh, that's right. Thank you. Andrew says Big Bang Theory, so it could be Leonard and Sheldon and Penny. That's right. So I may have to rework these at some point. All right, so you have Chandler from Alabama, works for a casebook company. It's called East Law Publications. East Law is incorporated, and it's got its PPOB in, sorry about that, in Connecticut. Chandler goes around the country. His job is to show law books to law professors. There are people that do this. I have some real good friends that work for the book companies. And Chandler goes to where? Alabama, Georgia, and Florida to go to various law schools to show the law books. While in Florida, he goes to a bar. He's in South Beach to have some fun, and he gets into a bar fight with Joey, a law student from Miami Beach, Florida. Chandler and Joey each blame one another for starting the fight. All right, lawsuit number 1. Chandler versus Joey in Alabama State Court for battery. Joey makes a special appearance to contest personal jurisdiction. Will Joey prevail on his objection to PJ? What do you think?
Yes.
Yes, he will. All right, in state court systems, you have what's called special appearance. The nature of special appearance varies from state to state. We'll get into that with some more hypos later. But the gist of this hypo is that Joey is a citizen of Florida, right? Nothing in the facts, nowhere in the facts does it tell us that Joey has any contacts with the state of Alabama. We see no constitutionally permissible basis for personal jurisdiction over Joey. So when Joey objects and he shows up and he makes the special appearance, the court should grant the motion and dismiss the lawsuit. A special appearance is when you show up and object to PJ. All right, question number 2. Chandler versus Joey in Alabama State Court. Battery. Joey makes a special appearance to contest PJ and also files a motion arguing that Chandler's complaint fails to state a claim. Will Joey prevail on his objection?
No.
It depends. It depends. And this isn't a fair question. So I actually had somebody come up to me before class and said, Professor, I really struggle with this question. And the reason is the book doesn't really go into this. So I'm going to explain it to you. In some state court systems, a special appearance means that the only thing you can litigate is PJ. Okay? In those court systems, if you go beyond objecting to PJ and make other objections, such as an objection on the merits, saying the complaint doesn't state a claim, then you will have waived any objections to PJ. In other words, going beyond objecting to PJ would make the special appearance become a general appearance, and you have now waived your objection, and therefore there's PJ. In such state court systems, Joey would be subject to PJ. However, some state court systems permit you to make a special appearance and enter in additional defenses, such as the defense of failure to state a claim. And that thus brings us up to question number 3. The same as question 2, except now the lawsuit is filed in Alabama federal court. Okay, so the same question. You know, Joey objects to PJ, and he says a complaint fails to state a claim. Will Joey prevail on his objection to PJ? And the answer here is very clear. The answer is yes. Now, again, this is an unfair question. Why? Because we really haven't talked about FRCP Rule 12 yet. Okay? Under Rule 12, you are permitted to make a pre-answer motion that joins together a number of defenses from 12b1 to 12b7. Okay, so a 12b2, as we noted in our earlier session, a 12b2 would be a pre-answer motion, if made by motion, be an objection to PJ. Okay, 12b1 would be an objection to subject matter. 12b6 would be an objection saying the complaint fails to state a claim. In the federal system, we don't make a special appearance. Instead, you make a Rule 12b motion. So what Joey could do is make a pre-answer motion. He can object to PJ. He can object failure to state a claim. He can object to subject matter jurisdiction, if appropriate. He could even object to venue. He could object to process or service of process and so on. And that's okay. And it's efficient because you can join together all those pre-answer defenses into one motion and have the court decide them all at one time. So Joey's his motion with multiple bases is not a waiver of PJ, and the court should grant his motion to dismiss for lack of PJ. All right. Question number 4. Joey versus Chandler in Hawaii State Court for battery. Chandler makes a special appearance to contest PJ. Will Chandler prevail on his objection to personal jurisdiction? The answer here is, of course, yes. No contacts with Hawaii. So you think, why in the world did Nathenson ask such an easy question? Well, then we get to question 5, right? Joey versus Chandler in Hawaii State Court for battery. Chandler, remember Chandler is a citizen of Alabama. Chandler from Alabama is served personally while sipping a Mai Tai while vacationing at the Honolulu Hilton on Waikiki Beach and attending the Law and Society Conference to promote law books to law professors. Chandler makes a special appearance to contest personal jurisdiction. Will Chandler prevail on his objection to personal jurisdiction?
No.
Probably not. Probably not. This is now a tag jurisdiction question, right? Under Scalia, there's going to be jurisdiction, right? He was voluntarily present there. He went there to sell books. Tag, he's it. That's the end of the analysis. No consideration of contacts, no consideration of reasonableness factors, right? Okay. Brennan is a little bit more fishy, right? It seems to him that physical presence in the state while you're personally served is kind of like super contact for all the reasons we discussed in our earlier session. All right. In fact, this is one you might want to write a practice essay to, right? It's like a mini test on the tag rule. All right. Question number 6. Joey versus Chandler in Alabama State Court for battery. Chandler defends on the merits and loses. On appeal, he asserts the court never had personal jurisdiction. Will Chandler prevail on his objection? Will Chandler will prevail. Got to fix that. Will Chandler prevail on his objection to personal jurisdiction? No. Will he? No. He will not. He will not for a bunch of reasons. Why will he not prevail on his objection to personal jurisdiction? I can think of 2 reasons. Yes? First of all, he defended on the merits. Did he object to personal jurisdiction at the trial court?
No.
Okay, so the wiser PJ, waiver, right? All right. There's another reason why his objection won't work, which is what?
He's domiciled in Alabama.
He's domiciled in Alabama. So even if he timely objected to PJ before the trial court, that objection would be not sustained, and the court would not dismiss the complaint. In fact, that's question 7, isn't it? Joey v. Chandler in Alabama State Court for battery. Chandler makes a special appearance to contest PJ, right? Will Chandler prevail on his objection to PJ? And of course, the answer is no. Domicile, right? And there you go. All right. Question 8 is a little bit harder.
7.
Did I skip over something? No, we just did 7.
No.
We did.
Yeah, we just said that.
Yeah,
We're going
we
on to
did.
question 8.
Quick question. I promise it's important.
Okay.
When you say usually when you say from Alabama, are you implying that they live there? Because I understood it as
Yes,
he hails
that's a
from there.
fair
Does it-
question. From Alabama means he's domiciled in Alabama. Okay. All right. Question 8. Joey v. Chandler in Alabama State Court for battery. Chandler does not contest personal jurisdiction and instead asserts a counterclaim against Joey for battery. You know, a counterclaim is when the defendant sues the plaintiff, right? Joey serves papers asserting a special appearance regarding Chandler's counterclaim and contesting personal jurisdiction. Will the court grant Joey's motion to dismiss the counterclaim for lack of personal jurisdiction? Yeah, probably not. Okay, now remember, what we have here procedurally is P sues D. So Joey, domiciled in Florida, versus Chandler, domiciled in Alabama court for battery. Now the defendant counterclaims against the Florida plaintiff, okay, saying, oh, well, you sue me for battery, I'm suing you for the same fight. Battery, okay? By going to Alabama, when Joey went to Alabama to file a suit against Chandler, a lot of courts would say that Joey has consented to jurisdiction for any counterclaims against him. And that's actually what the Glannon book says, okay? That a plaintiff that files suit is consenting to jurisdiction for any counterclaims against her or him, okay? But the reality is a little bit, in my opinion, the reality of the law is a little bit more subtle and difficult than the way our case book presents it. And here's why. The joinder rules permit Chandler to counterclaim against Joey for unrelated claims, all right? Suppose Joey sues Chandler for battery, and then Chandler counterclaims for an unrelated breach of contract, okay, involving stuff that happened in California, okay? See where I'm going with this? There's no tie between the claim and the counterclaim. The only commonality between the claim and the counterclaim is that they involve the same two litigants, right? Same plaintiff, same defendant. But the claim would be battery and the counterclaim would be an unrelated contract claim arising in another state. The law here is actually quite unclear, and if you're interested, you can look at the Federal Practice and Procedure Treatise, sections 1416 and 1424. You don't have to write it down right now, but when you look at the explanations that I have on the website that will go up shortly, you'll be able to get that citation. Federal Practice and Procedure is available on the Westlaw database. You just type FPP into the search field and click on Federal Practice and Procedure. You can read it for yourself. The law is quite unsettled regarding permissive counterclaims that are unrelated to the actual claim. Okay, so it's a warning. If the counterclaim is for the same thing as the claim, then it would appear there's PJ over the plaintiff. Okay, but if the counterclaim is for something completely different, courts may vary significantly. Hey, could you guys check on the heat again? It's like real warm in here. I can see it in your faces. When it's warm, oh, when it gets cold, we all perk up, and then we start to like become like little snow bunnies and get cold. So I want it to be just right. All right. Question number 9. Number 9. Joey versus Chandler in Florida State Court for battery. Chandler makes a special appearance to contest personal jurisdiction. Will Chandler prevail in his objection to personal jurisdiction? What do you think?
No.
No, minimum context, right? Minimum context. It's a basic example of what kind of jurisdiction, general or specific?
Specific.
That's right. And as easy as it is, let's go through the 3 steps real quick. Number 1, did Chandler purposely avail himself of Florida? Did he?
Yes.
Yeah, he went there. Okay. All right. He went there. Now he went there why? To show books, right? But he also chose to go to South Beach and go drinking in a bar, right? All right. And he got into a fight. Did his voluntary presence in a bar where he got into a fight give rise to the battery claim? Yeah, like under any test. Evidence, but for, related, whatever. It gave rise. Would it be reasonable to subject him to PJ?
Yes.
Well, first, there's purposeful availments. We presume reasonableness. Second, Now Chandler has the burden of showing a compelling case of unreasonableness, so he's got to show it's really unreasonable. And then if you look at all of the factors, right? Burden on the defendant, no, he goes down to Florida for work, right? He's from Alabama, it's not that far away, right? Interest of the states. Florida have an interest in stopping people from beating each other up in bars, right? And you go on and on and on and on. Does the plaintiff have an interest? Of course. So it's an easy case of specific jurisdiction. All right, that was question 9, wasn't it? All right, question 10 is a bit of a goofy one, but I like it. Joey versus Chandler in Florida State Court for breach of contract arising from the failure of East Law Publications to deliver a civil procedure horn book that Joey ordered from East Law's website. Chandler makes a special appearance to contest personal jurisdiction. Will Chandler prevail on his objection to personal jurisdiction? What do you think? Yes?
I think it's maybe, because if it's so related, there might be specific jurisdiction. But also, he ordered it from a website, so he didn't really, there was a contact. So I think it's maybe.
Well, let me give you a hint here. When we're assessing jurisdiction over Chandler, whose contacts should we be assessing? Those of Chandler or those of East Law?
East Law, right.
We assess each defendant's contacts individually. Now, Chandler is a sales rep, right? He went down to Florida. Did he go down to Florida in connection with the website?
No.
Was he selling books to students?
No.
No. What was he doing? He was showing books to law professors. He'd be the person that would come to my office and say, here's a new Civ Pro case book. Would you consider using it? Okay? So he's down there for things that are very vaguely related to law school case books, but he wasn't the person that sold the book to Joey, right? Joey's made a mistake, right? What's he done? He sued the wrong defendant, right? So what we've got to do is analyze the context, What we have here is actually a factually insufficient claim. Joey sued the wrong defendant. This hypo is here to remind us that we need to analyze each defendant's contacts individually. And it's hard to see how Chandler's contacts with Florida, getting to a bar fight, not related to the book at all, right? Going down to show books to law professors, well, that seems not related to Joey's particular purchase at all, or if it is, it's really tangential, right? So it's hard to see how we have specific jurisdiction. Are Chandler's contacts with Florida sufficient to support general jurisdiction? What do you think? What do you think? No way, right? Chandler's got to be either domiciled in Florida, but he's domiciled where? Alabama, right? Are his contacts so systematic and continuous that we're going to use footnote 19 of Daimler? No. All right. Let's see. Which question was that? Was that 10? All right. Yeah. And here's another trick question. Question 11. And this is here, even though it's tricky, it's here to get us thinking about an important point. Joey versus Chandler in Florida State Court for breach of contract arising from the failure of East Law Publications, on defendant, to deliver a civil procedure horn book that Joey ordered from East Law's website. Chandler defends on the merits and wins, as he ought to, right? Chandler didn't sell him the book, East Law did. Chandler defends on the merits and wins. Did the court properly exercise personal jurisdiction over Chandler? Yes, it did. Yes, it did. He showed up, defended on the merits. He waived his objection. He didn't enter a special appearance. There's personal jurisdiction over him. But guess what? He's happy because he won the lawsuit, right? See? Merits and PJ aren't the same thing. All right. Question 12. Now Joey's suing the right person. Joey, citizen of Florida, versus East Law Publications, citizen of Connecticut, in Florida State Court for breach of contract arising from the failure of East to deliver the book, okay, through East Law's interactive commercial website. Website permitted Joey to order a book, enter credit card info, and ask the book be shipped to his home in Florida. East Law enters a special appearance to contest PJ. Will East prevail? What do you think? Will East prevail on its objection to personal jurisdiction in Florida State Court? What do you think?
Negative.
No.
Yes.
I think you can argue it both ways. Probably the better answer is that there is PJ. So the answer is no. Will East prevail? No. And we get into the difficulty of Burger King, right? The difficulty of Burger King. This isn't a long-term contract. It's not negotiated for a long period of time, right? On the other hand, East law seems to be reaching out everywhere and entering into contracts with people. Remember that the facts tell you that Joey had to enter into his address, right? So if East didn't want to sell books to people located in Florida, it could have said, sorry, we don't want to be subject to PJ in Florida. By agreeing to sell the book, it may be reaching out, maybe purposely availing itself of Florida, right? So there's an argument to be made, a pretty strong one, that East is subject to personal jurisdiction. Now what East ought to do here is have a forum selection clause, right? Yes?
I know Chandler deals with law professors, but with the fact that they have an agent in Florida promoting their product, can also affect PJ?
That's a wonderful question. I love this question, and the answer is yes. Here was the question. Would the fact that the East has a sales agent going to Florida to promote its books, namely Chandler, right, would that also tilt towards PJ? And I think the answer is yes. So, in fact, what we really have here is this is kind of like a Zippo-like fact pattern. Remember how I said that in website cases, the courts will oftentimes look to the commercial interactivity of their website? And here are the facts that say that East has a commercial interactive website. In the internet cases, the courts will oftentimes look at both internet contacts as well as real-world contacts, right? Now here, the main contact seems to be the website, right? And that's what directly gave rise to the claim, right? Go to the website, order the book doesn't come up, it doesn't appear, and the website becomes not just a jurisdictional contact, but one that's evidence and gave rise to the claim, and is but for a cause of the claim. But then the court might look at the fact of other additional contacts. The East sends its sales rep into Florida to encourage sales of books, because if I agree to use the East book, then all you guys are going to be asked to buy it, right? So then you think, well, did that contact give rise to the claim? Well, probably not, right? Because using Chandler didn't cause Joey to buy the book off the website. But on the other hand, it seems to have some sort of loose connection to claim. The court might look at that as an additional reason, tilting the scale towards personal jurisdiction, right? Remember, the court says in Burger King that a weak showing of purposeful availment can be boosted by a strong showing of reasonableness. Well, kind of by analogy, this is an example of we have maybe a semi-decent, semi-not-so-strong showing of purposeful availment through the website. Maybe it's boosted just a little bit by the fact that Chandler goes there too, right? And this is the kind of analyzing that the courts will oftentimes do. Yes?
Would this be considered to be synonymous with worldwide, where it's a unilateral action on the consumer and the company is just sitting back and actually they're interacting with the company's not actually pursuing them?
Yeah, I understand the argument. You're thinking that there's no purposeful availment by worldwide, but there's no purposeful availment by East because it's Joey that reached out to East's website, right? And I think that argument would probably fail because East, keep in mind that East is pushing its website out, and then when Joey reaches to East is then agreeing that I'm going to ship the book to you in Florida. Think, for example, what would happen if East ships the book to Joey, and then after the book ships, say the credit card company reverses the payment on the credit card and says, sorry, East, we're taking back the money we gave you for Joey's book, right? Would East have the right to go to Florida, use Florida courts to sue Joey for breach of contract? Yeah, right?
Yeah,
So doesn't East, by agreeing to sell a book to somebody in Florida, reach out to Florida and get the benefits and protections of the Florida laws pursuant to that contract? Having said that, I think your one-shot contracts make for a difficult case for PJ, because most contracts aren't, these thought-out, negotiated, multi-million-dollar contracts that involve huge negotiation, course of dealing, and years of anticipated future consequences. That's why Burger King is so utterly unhelpful. Now let me give you a bit more pragmatic advice, okay? What matters is if you get a question like this on an essay, how would you argue it and counter-argue it, right? Question like, so write up the answer, show it to me. I'd love to see what you have to say. Convince me I'm wrong, right? Convince me that I should rethink the question. That's what I want to see, right? Make those arguments, make those counter-arguments. With these hypos, you'll see in my answer, some of them it's like a, well, probably yes, or hard to say, and with other ones, it's just a boom, yes, or a no, right? This is a harder one. All right, which question was that, 11? That was 12, thank you. All right, 13. Joey versus Chandler in Georgia State Court for battery. Chandler is served personally with papers at home in Alabama. Chandler makes a special appearance to contest personal jurisdiction. Will Chandler prevail on his objection to personal jurisdiction? What do you think?
Yes.
Yeah, it's a little trick question, right? It's an example of why you always read the facts really carefully. Not just in an exam, whether it's an essay, not just in an exam, whether it's a multiple choice, but also in the practice of law. Words matter. Changing one word changed the whole meaning, right? What if Chandler was personally served in Georgia? We'd have a different answer, right? All right, so he was personally served in Alabama and not in the forum state, Georgia, okay? And he wasn't sued in Alabama, where he lives. Instead, we'd have to ask about what? The minimum contacts with Georgia. Does Chandler have any contacts with Georgia? Yes, he does. And look back at the original fact pattern. He visits Alabama, Georgia, and Florida to show the books, okay? Is there some like tangential relationship between visiting profs and let's see, the battery? No, probably not. Probably not. I mean, you could try to argue, but for him going to Georgia, he would have then later on gone to Florida, show more books, and then to like deal with all the stress of dealing with law professors, he would then go to the bar in the South Beach, have a few
Contacts.
and then see Joey, boom, and get in the fight. Wow, that seems pretty tenuous, doesn't it? So that's kind of the analysis, right? But it seems like the best answer here is there be no PJ. Okay. Question number 14. Joey versus Chandler in Georgia. Which one was we on? 14? Okay. Joey versus Joey versus Chandler in Georgia State Court for battery. Chandler is personally served with papers at home in Alabama. He thinks Joey does not have personal jurisdiction and decides to ignore the litigation. Oh, scary move. The Georgia court enters a default judgment against Chandler. Joey later files papers to enforce the Georgia judgment in Alabama, think of full faith and credit, right? And force a sheriff's sale of Chandler's Alabama home. Assume that Chandler plans to challenge the Georgia court's personal jurisdiction in the Alabama proceedings. Will Chandler prevail on his objection to personal jurisdiction? What do you think?
Yes.
Yes.
Yes, he will.
Collateral.
This is a collateral attack. This is just like Pennoyer versus Neff, right? There's a default judgment against Mr. Neff. He didn't even presumably know about the lawsuit of Mitchell versus Neff. He doesn't show up. He later finds out, and in a later proceeding attacks the validity of the original judgment. But definitionally, keep in mind, you want to think about the distinction between the rendering court and the enforcing court. Okay? The rendering court here is the Georgia State Court that issued the default judgment. The enforcing court is the second litigation, and that here would be the Alabama proceedings that attack sufficiency of the original judgment. Okay. By the way, enforcing an out-of-state judgment, when you enforce the judgment of the original rendering court, that's called domesticating a judgment. Domesticating a judgment, yes.
What if it's within a 100-mile radius?
Within a 100-mile radius?
No.
No, I think you're thinking of the bulge rule. The bulge rule is not an issue in this fact pattern. All right, question 16. 15, question 15. Thank you. Joey versus Chandler. In Georgia State Court for battery, Chandler is personally served with papers at home in Alabama. He especially appears and challenges personal jurisdiction. Amazingly, the state court judge finds there is personal jurisdiction. Well, let's just think about it. Do we agree with the state court judge? No, we don't. But he was served personally at home. Yeah, but home is Alabama. The lawsuit's in Georgia. Okay, so the judge got it wrong. Angry, Chandler refuses to participate further. He goes home. So this is I'm taking my ball, my bat, and going home. The Georgia court later enforces a default judgment against Chandler on the merits. Some months later, Joey files papers to enforce the Georgia judgment in Alabama and force a sheriff's sale of Chandler's Alabama home. So we have the rendering court, right? That's the default judgment in Alabama. Or excuse me, that's the default judgment in Georgia. And then we have the enforcing court. That would be the sheriff's sale proceedings in Alabama, right? Assume Chandler, again, for the second time, challenges personal jurisdiction of the Georgia court. Will Chandler prevail on his second objection to personal jurisdiction?
No.
No. He will not.
She waived.
He will not. He will not prevail in the objection. Okay. This is actually because of something we haven't studied yet called issue preclusion, also known as collateral estoppel. Personal jurisdiction is not a claim, right? Like, think of it. Personal jurisdiction is not a claim. Personal jurisdiction doesn't entitle you to relief. I'm subject to PJ in Florida because I am domiciled in Florida. So there's all-purpose jurisdiction against me. I can be sued for anything in the world in Florida, okay? And there'd be PJ. But PJ by itself is not a claim. It's just issue in a litigation, all right? Under issue litigation, I get to litigate the issue of PJ how many times? Once. Now, if I don't show up, if I'm sued, say like in Alabama, and I'm thinking there's no PJ against me in Alabama, I decide not to show up and there's a default, okay, well I haven't yet litigated that issue. So if I then want to attack it collaterally like the prior fact pattern, that's okay, because the issue of PJ has not yet been actually litigated, all right? However, in this fact pattern, Chandler did something really dumb, right? He went to Georgia, litigated the issue of PJ, and he lost, and he was so mad and he left. Well, guess what? It's too late, all right? And then there was the default judgment against him. Boo-hoo for him, okay? When he attacks it later on collaterally, it's too late for him to relitigate that issue, because collateral estoppel stops him. It prevents him from relitigating that issue. Okay? And because there was PJ, even though the court decided wrongly, it was decided, and it's final, all right? Even though that issue was wrongly decided, it was decided, it can't be revisited, and because there was PJ, he can't attack the default judgment. It's done. So it's very dangerous to do. It's really dumb to do what this fact pattern does, okay? Now, the question is, what should Chandler have done? Instead of taking his ball on his bat and going home, what should Chandler have done when the state court judge wrongly decided PJ? Yes?
Could he put it up for appeal immediately or wait until the final judgment and ask for an appeal on PJ?
Yes, the possibility of appeal, which is a real catch-22. You know, catch-22 means an impossible choice. In the federal system, you really can't immediately appeal an adverse finding of that there's PJ. Judge says there's PJ in the federal system, that's typically not going to be immediately appealable. Instead, you're going to have to wait until later on when you have, for example, a final judgment ending the case, and then you can appeal. But that could be years later, right? Very expensive. In some state court systems, like California, some state court systems not only permit, but require a decision like this to be immediately appealed. In other words, not an appeal of a final judgment, but an appeal of an interlocutory order. Interlocutory means the case is not over, but if interlocutory appeal is permitted, then we permit an immediate appeal. So if we were in California and the court said that Chandler was subject to PJ and Chandler thinks the court got it wrong, Chandler not only may, Chandler must immediately appeal that issue to the intermediate appellate court in California. In the appellate system, though, he'd be stuck. You know, you may have to like stick it out, go through summary judgment or even through a trial before he could try to appeal that matter. So it is some small solace to Chandler that he could appeal, but it might not be a very viable option because he might have to wait a really, really long time. Okay. So was that question 15?
15.
All right. 16. Oh, we're making really good time. Let's see. Joey sues Chandler in federal court in Gainesville, Georgia for battery. After being served, Chandler suspects the cause of a South Beach bar fight was a faulty prescription from a pharmacy he visited in Clemson, South Carolina, a day or two before his trip to Florida. Chandler thinks that the pharmacy gave him the wrong pills, causing him to Hulk out and hit Joey, and that the pharmacy is therefore at least partially to blame for any liability Chandler may owe Joey. Assume the pharmacy in Clemson is about 75 miles from the federal district court in Gainesville, Georgia. Chandler brings in the pharmacy as a third-party defendant, and here I made some minor amendments to this to clarify this. I did those last night, so you want to look up on the screen. A third-party defendant alleging the pharmacy is liable to Chandler by contribution for all or part of any damages that Chandler may owe to Joey. Will the pharmacy be subject to in personam jurisdiction? What do you say?
Yeah.
Yes.
Bold.
Bulge rule, right? This is the bulge rule.
K1.
The pharmacy was joined as the third-party defendant. You know, you have plaintiff sues defendant. Then the defendant brings in the pharmacy as a third-party defendant, saying, hey, you pharmacy, anything I owe the plaintiff, you owe all or part of that to me. You have to contribute to me to make me partially or completely whole for my liability over to the plaintiff. Okay? That's third-party practice. And plus, the pharmacy is located in a federal judicial district, right? And was served no more than 100 miles from the courthouse. Yes?
I think it wasn't.
Oh, sorry. No, I didn't think that there was PJ in Georgia, though. I thought that there was only PJ in Florida.
So we say it's Gainesville,
No, don't. One person,
Florida.
Yeah,
one
but-
person at a time.
But I thought the bulge rule is to bring in third parties within 100 miles. And
And the same.
Oh, I'm on the wrong page. We're on,
Yeah.
we're on 16, right?
In South Carolina.
Let's see. Okay, the lawsuit is in Georgia.
yeah, but if they
Let me look at the fact pattern. Let me think about it. The
Yep.
lawsuit is in Georgia, and the pharmacy is in Clemson, South Carolina. Okay, no, that's incorrect. Where's the lawsuit been filed?
in Georgia.
In Georgia. And where's the pharmacy?
And I didn't think.
And how far is the pharmacy from the Georgia courthouse?
Right, 75 miles.
75 miles. So how do, your question, I understand your question to mean is how do we measure the 100 miles, right?
No, it's,
The 100 miles is measured where? From the bar fight in Florida or from the courthouse in Georgia?
no, I get that it's from the 100 mile, from the courthouse in Georgia. That's
Okay.
just- I don't understand how Georgia is BJ unless he waived it or
Mhm.
presented the Chandler.
Oh, you're wondering why Chandler is subject to PJ?
Right. because
Oh, that's easy. Why is Chandler subject to PJ?
Georgia?
No, why is Chandler subject to PJ?
That's what I just done.
Why is Chandler subject to PJ in Georgia? Why?
Was he brought to the pharmacy?
Nope,
Federal.
nope.
Yeah.
Why is Chandler subject to PJ? You're asking about PJ over Chandler. The question is asking about PJ over the pharmacy,
But that's
right?
another
Don't interrupt. The question is not about PJ over Chandler, right? The question asks about PJ over the pharmacy. We're all clear that the bulge rule provides PJ over the pharmacy, right? But you want to ask about PJ over Chandler, which is fair enough. Why is there PJ over Chandler?
Well, he added the third party, so it concerned it to the PJ.
True. I like that answer. Let's take that to its completion. Yes?
In the fact pattern, his assignment for the week is visits Alabama, Georgia, Florida.
No.
He has personal contact.
No. Why is Chandler subject to PJ in Georgia? Did he file a special appearance?
No.
What happens if you don't make a special appearance? There's PJ. It's that simple. I'm in Florida. I get into a bar fight in Florida with somebody from Florida, okay? The plaintiff sues me in Alaska, all right? Do I have any contacts with Alaska? Suppose I go to Alaska and litigate on the merits without making a special appearance. Is there PJ over me?
Yes.
Yes. So there's your answer. Showing up and litigating on the merits without filing your objection to PJ means there's PJ.
It didn't.
So you're asking, why is there PJ? Well, there's not a constitutional basis here that we can identify for PJ, but it doesn't matter because waiver. There's no minimum contacts here for PJ, all right? But there's waiver. I'll take the question further outside of the discussion. We'll move on. All right. Question 17. Joey planned to sue Chandler in state court in Georgia for battery. His pre-filing investigation of Chandler showed that Chandler kept a valuable collection of fine wines in a climate-controlled facility in Georgia. Joey therefore filed suit against Chandler in Georgia and at the same time attached Chandler's wine collection. Please don't talk because we're recording the video, okay? Thank you. He therefore filed suit against Chandler in Georgia and at the same time attached Chandler's wine collection. Chandler wants to go to Georgia to contest jurisdiction, but is concerned about whether Joey can use his wine collection to obtain jurisdiction. Can Joey use Chandler's Georgia-based wine collection to obtain jurisdiction? What do you think? No. This is an example of quasi and rem type 2B jurisdiction, right? Yeah, under Schaffer. Schaffer tells us that if we're talking about quasi and rem jurisdiction, that at least Marshall says for quasi and rem, in fact for any assertion, use minimum contacts. Here, this is quasi and rem. Here, the property is completely unrelated to the lawsuit, and therefore, there's just not enough context. I suppose we could argue there are some contacts with the state of Georgia, right? Because the defendant did go to Georgia to show books to law professors, but that has such a tenuous relation, if any, to the battery claim. So it looks like there's no quasi and rem jurisdiction. And here the concurrences in Schaffer don't help us, because concurrences say what? In the case of real property, use the old Penoyer test, right? But wine collection is not real property, right? So it's personal property, right? So, it doesn't appear that there's going to be jurisdiction. All right. What was that, 17 or 18?
17.
All right, 18. Joey planned to sue Chandler in state court in Georgia for battery. His pre-filing investigation of Chandler showed Chandler owned a vacation home on Lake Lanier near Atlanta, Georgia. Joey filed suit against Chandler in Georgia and attached the vacation home. Will Joey be able to base jurisdiction on the Georgia vacation home? What do you think? I like the tone of the answers, like, well, yeah, no, I don't know, well, it kind of depends. I don't know, right? What would Marshall say? Would Marshall permit jurisdiction to attach from the vacation home? Yes or no?
No.
It would be no. Because this is quasi and rem type 2B. Vacation home has no relationship to the battery in Florida. All right, but what about the concurrences, right? Concurrences say, look to real property. Under real property, maybe you want to use the Penoyer rule. So there you go. It depends, again, as before, how broadly do we read Schaffer? Okay. Now finally, we have a new fact pattern, 19 through 21. It's based on a very extensive fact pattern. This is an excellent opportunity for you to write up for me a practice essay based on the stream of commerce formulation. So just write it up. Show it to me. In fact, the fact that you would know what the analysis basically would be, I think helps you more. Do you guys see that blog posting I made about a week ago saying there's 2 skills in writing an essay? Number 1 is knowing the law. Number 2 is being able to organize it and get it down on paper. I think when you already kind of know what the law and the answer is, that helps you to focus on that second skill, organizing it and getting it down on paper, okay? So I think this is a good one for you maybe to write up. All right, Shredder Strings. Kobe, Japan makes strings, sells the strings to retailers in the eastern U.S. And it sells strings to guitar manufacturers to incorporate into their products. All right, now we have Nutty Pegs. Florida makes tuning pegs, sells components to guitar manufacturers, and it specifically designed its pegs for the style used by today's West Coast rockers who mostly live in Southern California. We know that California is going to be the forum state, right? So you should immediately be thinking about what? Stream of commerce. Stream of commerce, right? When we're designing the goods for the forum state, who does that remind us of? Plus O'Connor, right? All right. See how facts trigger legal issues? All right. Fender is a guitar manufacturer in Tennessee, sells nationwide, uses shredder, strings, and nutty pegs in its instruments. The materials accompanying Fender guitars do not indicate the shredder strings or nutty pegs are used in Fender guitars. Shredder and nutty pegs are nevertheless very proud that their products are used by a national company like Fender. Why is that fact important?
Because they know.
Awareness, right, from Brennan?
Brent.
Awareness that the goods are going to be marketed in the foreign state. Woohoo! Now Eddie, now we finally get to our plan. Eddie purchases a Fender guitar from a Fender guitar store in California. How many people missed that fact? As a true guitar freak, Eddie has exhaustively researched the source of every component of the guitar, including the source of the strings and pegs. He takes the guitar to his home in Santa Monica, California, and plays it. While playing it, a string breaks and creates an ugly gash on poor Eddie's face. Question 19. Eddie sues Fender in California State Court. Does the California court have PJ over Fender? Yes or no?
Yes.
Yes, it does. It's easy peasy. Is this a stream of commerce question?
No.
It's not. I'm betting some of you being quiet thought, oh, it's a stream of commerce question. What are you talking about? Where did Eddie buy the guitar? From what kind of store?
Fender.
Fender store. Who sold the guitar to him?
Fender.
Fender. Is that a stream of commerce fact pattern? No, it's a direct sale by the defendant that has operations in the state, and the in-state sale gave direct rise to the lawsuit, right? Easy peasy case of specific jurisdiction. All right. Question 20. Eddie sues Nutty Pegs in California State Court. Does the California court have jurisdiction over Nutty Pegs? What do you think?
Awareness?
There's a very strong argument.
Yeah.
Now, is this a stream of commerce fact pattern?
Yeah.
Heck yeah, we got a component, right? It was included in the final product that was sold in California. All right, St. Brendan. Was Nutty Pegs aware that its tuning pegs would be incorporated in guitars and sold all over the country?
Yes.
Was it aware that its pegs would be sold in guitars that were sold in California?
Yes.
Yeah, I mean, California, there's lots of guitar players there, right? So, yeah, it kind of was. Brennan would appear to be satisfied. And Fender's a national company, so it would appear we have regular and anticipated sales of the finished goods bearing the Nutty Pegs tuning pegs, right? Brennan says yes. O'Connor. Well, first, is Brennan satisfied? Yes, that's the first step of O'Connor. Second, one or more of the plus factors.
Reasonable.
What's that?
Reasonable.
Oh, no, not reasonableness. We're not even close to there yet. Are any of O'Connor's plus factors satisfied? Designing. Yeah, the pegs were specifically designed for the rockers in the California market. Well, that sounds almost exactly like one of O'Connor's plus factors, designing your goods for the foreign state, right? So there you go. O'Connor appears to be satisfied. And Stevens, I love Stevens. He wears bow ties. Stevens is awesome. He's smart and he's a nice guy and I adore him, but I don't like his test. Sorry, Justice. Okay. Tuning pegs. The volume. How many sold? I don't know. How many guitars? How many pegs does it sell a year? Probably thousands, but maybe a couple thousands of them every year in California. How much is the value? How much do you think tuning pegs cost for a guitar?
$200.
Few cents.
200? No, not unless they're like gold plated or something like that.
Cents.
No, you can buy a guitar for like $100. Probably cheap pegs are probably a couple bucks. Good quality pegs probably cost you $20, $30 for a good set. Be my guess. Dangerous? Are they dangerous? Well, I mean, if they cut into springs, I would say if the holes inside the tuning pegs are cut too sharp, it might slice the string up at the tuning peg and create a risk of breakage, right? Anybody play guitar, you know what I mean? Yeah. There's that hole that's bored inside the tuning peg. Just here's the peg, okay? You turn it like that. There's a hole inside of it, and when you string the string goes through the hole and you loop it through. Well, the hole's got to be big enough to fit the string, but if you bore the hole so sharp in the internal edges that it's like a razor blade, I think it creates a risk of breakage, right? So I suppose in theory a tuning peg can be dangerous, right? So maybe a little bit dangerous. You see how unhelpful Justice Stevens' test is? So I don't know. But O'Connor, yeah. Brennan, yeah. And there you go. The other factors. Did the tuning pegs give rise to claim? Well, Eddie's suing the tuning peg company, right? Saying the pegs caused, in whole or in part, the string to break, right? So that seems to be satisfied evidence or but for. And reasonableness factors, right? Go through them yourself. First of all, keep in mind the most important consideration. We presume that it is reasonable for PJ. And now Nutty Pegs has to prove compelling unreasonableness. And doesn't seem particularly unreasonable, especially when Nutty Pegs is designing its tuning pegs for the California market. You know, so there you go. Now question 21. Whoops, never showed them on the screen. There you go, for those of you playing along at home. It's question 19 and 20, and you can get these on the website as well. Question 21. Eddie sues Shredder Strings in California. Does the California court have personal jurisdiction over Shredder Strings? What do you think? What do you think? Hey, you know what? This is why it's a great essay question. Let's think about it. Brennan. Is there purposeful availment under Brennan?
Yes.
Regular and anticipated flow. Shredder Strings was very, remember the fact said, Shredder Strings is very proud that its strings were sold in Fender guitars. You know, it should recognize that its strings will be sold in California. Okay. O'Connor. Were the strings designed for California? Any facts showing advice being given in California?
They made it for.
No. Any sales agent? No, not that we know of, right? And so on and so forth. It would appear that O'Connor would be unsatisfied. You know, that it's not enough for O'Connor that there's mere stream of commerce. There's no plus factors. So whether there's purposeful availment or not depends on which justice you go to. Then you get to the volume, value, and hazardousness of Stevens, and it's still kind of indeterminate. Okay, did the strings give rise to the claim? Well, I mean, if you accept Brennan's view, then the strings gave rise to the claim. What about the reasonableness factors? Even if we follow Brennan, reasonableness factors. Okay, who's got the burden of showing unreasonableness? Shredder Strings, right? All right, does the plaintiff have an interest in litigating in California? Yeah, that's where he lives, right? Does California have an interest in preventing injuries to its citizens? Yes. Is it inconvenient for Shredder Strings to litigate in California?
Yes.
Yes.
It is, but you know, I mean, it's selling directly to the United States market, right? It sells to the East Coast. Is it that inconvenient? It's a little inconvenient, but it's not inconvenient like in the Asahi case where you had two Asian companies fighting over indemnification, right? So you see what I mean? Ultimately unreasonable? You can argue a little bit. Compellingly unreasonable? Perhaps not. Aha! This is like the hypo where Mr. Zerker sues Asahi. All right. So again, it's a potentially helpful fact pattern. All right, how are we on the time? We started when? About an hour ago. I think we will finish up with the rest of these questions relatively quickly. Questions 22 through 24 are kind of like McGee versus International Life combined with Hansen versus Dental. So the facts. Hannah sees an ad in a local Miami newspaper for low rates on term life insurance policies. She contacts the National Life Insurance Company and purchases a term policy. For the next 20 years, makes payments to the company via the mail. The company sends her statements and policy updates. Deciding that she wants to be closer to her grandkids, she moves to Texas. She writes National Life with her updated contact info. National Life continues to bill her in Texas. She passes away at 90. The insurer refuses to provide coverage, arguing that Hannah has made a material misstatement on her original application. Wow. And I moved this from a later question. I added this up here. I did this just last night. National Life has its headquarters in LA and is incorporated in Delaware. All right. Question 22. The beneficiary, Arthur, wants to file suit against National Life Insurance Company in Texas. National Life has never had any customers in Texas besides Hannah. Will Arthur succeed in asserting personal jurisdiction against National Life? What do you think?
Yes.
Oh, I'm hearing yes and no. What would be the argument yes? I'm curious. What's the argument? Argument yes, there's personal jurisdiction. Yes.
They agreed to still build her there.
What's that?
They still agreed to build her when she was in Texas.
Yeah, but wasn't that true in
They just agree to bill her, they're not reaching out to Texas in entirety or any other.
I suppose
They're continuing the offer. So If they didn't want to purposely avail themselves to Texas, they would have been like, sorry, I have to.
We don't want to service Texas anymore. Okay, yes.
I mean, if they didn't, if she stopped paying, they can sue her in Texas to get their money back. That's the purpose of it.
Oh, well, the whole life policy, the way it works is, excuse me, this was a term life policy. This is a term policy. You're not investing any money in the policy, so if you stop paying, then they just won't pay for a debt that happens after the policy lapses. So unless she had a past due payment for a period that was covered, there would probably be no lawsuit. They would probably just cancel the coverage effective the date of the end of the last term. Yes?
Isn't this just like that case of the older lady in the other state?
That would be Hannah, right? So the question here is, did National Life, did National Life reach out to Texas? Did it purposely avail itself to Texas? Or did she take a policy with her? That's the thing I want you to think about.
They're just doing her the favor to continue billing her in Texas. They're in no way reaching out to that state at all.
Well, I like both arguments. Now let me add some additional facts to clarify the fact pattern for purposes of our discussion. Let's assume the terms of the policy, and this is what I'm assuming, but you're bringing on an interesting issue, Keneally, so let me give you some additional facts that may affect the analysis. Let's assume that the policy as entered into by Hannah was the policy would remain in effect as long as she kept paying it every year, okay? And that National Life wouldn't cancel the policy as long as she kept paying it, okay? That's what I'm assuming, and I think that I need to put that in the facts to make it a little bit clearer. How might that affect the analysis? National Life can't cancel the policy unless she stops paying, and they agree to keep the policy in force as long as she's keeps paying.
Then I think that they would purposely avail themselves to Texas.
Okay, then we have something, I think, which is what you're getting at, which is something much more similar to Hannah versus Denkler, right? So what you said was, if the insurance company didn't have the option of canceling the policy, except in the case of non-payment, and it would keep servicing the policy, then we would have something like Hansen versus Denkler, where the settler of the trust moved from, I think, Pennsylvania down to Florida, and she took the trust with her, and then the trust company kept servicing the policy. But having said that, you really do raise a very interesting question, Keneally, regarding, would sending the bills continually to the state, might that arguably constitute purposeful availment? So let's move on to the next question. So I like your analysis. And that was question 22, right? Let's go on to question 23. Hannah's beneficiary, the grandson Arthur, wants to file suit against National Life in Texas. National Life has sold whole life insurance policies to thousands of Texas residents for over 20 years, but has never sold or maintained any term life policy for any Texas resident except for the Florida policy it continued to service in Texas for Hannah. Will Arthur succeed in asserting personal jurisdiction against National Life? What do you think? Well, let's go through the steps. Did National Life purposely avail itself of Texas? What do you think?
Yes.
It did, and it has lots of policies. What was it to say? Does it say how many? Thousands. I'm losing myself. We're at 23, right? Thousands of policies. So definitely it has purposely availed itself. Do you think it's the continuous and systematic contacts that render it essentially at home? Really? No, I don't think so at all. Remember, in the Daimler case, the Supreme Court says that general jurisdiction is limited to PPOB and incorporated, and in the exceptional case, something akin to that. Okay, now, National Life, where did I say it was from?
Delaware.
That's right, it was from Delaware. It's headquarters in Los Angeles, incorporated in Delaware. So it's subject to general jurisdiction in those two places. But I don't want you to think that having thousands of policies means there's going to be general jurisdiction. Think of any large insurance company. Wouldn't it have thousands of policies with residents of every single state of the country? By that analysis, there'd be general jurisdiction against an insurance company in every state of the country. Or think, for example, of any large national corporation. that it has a whole bunch of stores in, right? How broadly can we read footnote, 19 of Diamond, right? So I think it would be wrong to say that the mere fact of thousands of policies would be enough to have general jurisdiction, okay? Continuous and systematic contacts, yes. Continuous and systematic and so substantial that the defendant is essentially at home, I don't think so. Now, what about specific jurisdiction, okay? Again, did this defendant purposely avail itself of Texas? What do you think?
Yeah.
Did it? Did it?
Yeah.
Yes, it did. All right. And continuously and systematically, not essentially at home, but pursuant to a pattern for a long period of time. I want to get out of your mind, continuous and systematic does not automatically mean general jurisdiction. You need something more. So continuous, systematic, and substantial that you're essentially at home, which means PPOB or Inc. in this case of a corporation, and maybe the rare exceptional case. This is not that rare or exceptional case. So we're limited to specific. We do have systematic and continuous contacts. I agree with you on that. Did those contacts give rise to Arthur's claim? Did these thousands of whole life policies give rise to the claim for non-payment of this term life policy? You see what I mean? Well, are the thousands of whole life policies evidence of the non-payment of this single term life claim? Is it evidence? What do you think? Probably not. Different policies, probably different terms, different fact patterns. No, those whole life policies, do you know the difference between whole and term? Whole life is like an investment policy. You pay on the policy, and then later on, even if you don't die, you get some money back. So it's a way of saving money, okay? A term policy is you pay X number of dollars a year, and if you die within that year, your beneficiaries get paid. But after the policy is over, say like I have term life policies, okay? I don't have whole life. Say at the age of 70, I decide, the heck with term life policies. Why am I paying money into this? My kids are grown. We've got Social Security. We've got savings. I don't need life insurance. My wife doesn't need it, right? So I stop paying on the term life policies. Now if I die, my spouse gets nothing, okay? Because the term policy is expired. Whole life you save money and get a payout if you die, all right? And even if you don't die, you get money. Term life is just if you die within the policy year, the beneficiaries get paid. But you guys are mostly young and you wouldn't know that, would you? You don't even like talking about life insurance. It reminds us that we're all gonna die. Oh yeah, nobody wants to talk about life insurance. Okay, well, who wants to talk to a life insurance agent anyway? All right. So, did the thousands of whole life policies, are they evidence of the breach of Arthur's policy, of what's her name's, of Hannah's policy? No. But for the thousands of policies, there wouldn't have been a breach of the type policies? No. What about the third branch? Are those whole policies somehow sufficiently related to the term policy? Kind of hard to say, right? Well, if we don't have all these contacts giving rise to the claim, that means there's no specific jurisdiction, right? And if there's no specific jurisdiction, we'd have to have general jurisdiction, right? But systematic and continuous isn't enough for general jurisdiction. It's got to be a really big level of systematic and continuous, essentially at home, right? So this is an example of a good fact pattern for an essay question, because it forces you to think about all the steps of specific jurisdiction, forces you to think about all the steps of general jurisdiction, to think about the difference of them, think about the evidence test, the but-for test, and all of them. It's a hard question, no doubt about it. All right, question 24 in contrast is a lot easier, isn't it? After moving to Texas, National Life wrote Hannah, I know Canelli will like this question. After moving to Texas, National Life writes Hannah and asks if she would like to boost her coverage. She accepts the offer. National Life has a few customers in Texas over the past 20 years besides Hannah. Will Arthur succeed in asserting personal jurisdiction against National Life? What do you guys think?
Yes.
Yes. This is like McGee, right? We have a solicitation by the company in the state of Texas, okay? The plaintiff accepted the offer, and that boosted policy is what gave rise to the claim. Much, much easier fact pattern. All right, our last two questions. Our last two questions. You know what? I said we'd be here from like 1 to 5. Look at what time it is now. It's about 5 minutes to 5. I'm still going strong. I can talk about this stuff another 10 hours. I don't want to, but I could. Danny from New York, no relation to Danny Bonaducci, was a child star who worked on a once popular television show, The Pigeon Family. As a teenager, he had a crush on the star of the show, Shirley from California, domiciled in California. As a respectable woman, Shirley had been kind to Danny, but firmly told him that she was too old for him and that someday he would find true love. Aww. Danny, however, never got over Shirley. Many years later, Danny became a disc jockey at a local radio station in New York. One day on the show, he confessed his love for Shirley. Feeling bold, he made up lies about Shirley, saying the two had romantic interludes on the sets in Hollywood, California, when he was 16. And more recently at her Santa Monica, California home. Lies, lies, lies. The ensuing press nightmare ruined Shirley's career. Question 25. Shirley sues Danny in California State Court for defamation. Does the court have PJ over Danny? What do you think?
Yes.
Yeah, this seems like a very basic recitation of Calder, right?
Yeah.
Intentional tort, defamation, right? Front of the heart, Forum State, California, suffered by Shirley. Focus of the conduct. Well, first of all, the story is about things that allegedly, but actually didn't, happen in California, right? And the focus is a little, here's the hard issue here is Danny in this hypo, is he actually aiming his story to California? That's the thing, the debatable point, right? The story's about California, but his conduct is aimed at listeners where? New York. Okay, so there's your gray fact pattern. I think the court would probably find there's PJ, but there's some indeterminacy here on that conduct element. Yeah, Andrew.
On the Volkswagen case, in this case, he's a local DJ, and the news and the gossip is brought to California by a third party, which is the press. So I could say that it was the press, who is a third party, who brought the information and gossip to California. So technically, using the Volkswagen case, I could say, or I would argue that he cannot be sued for the same reason in California.
Did everybody hear that? That was a really nice argument that Andrew just made. It was something like this. Under Worldwide Volkswagen, we look to what the defendant did reaching out to the forum state. Here the forum state is California. Well, the defendant was aiming at a local audience, okay? And to the extent that the story gets to California, it's because third parties pick up the story that was broadcast over the New York radio market. And those third parties are the one that spread the vile gossip to the state of California. Just like the car in Worldwide got to Oklahoma, not because the defendants sent it there or sold it there, it's because the plaintiffs drove it there. Nice argument. 26, I think the answer is going to be probably not, right? So here's our last question. Because of the press debacle, actually, yeah, please don't shuffle around the papers just yet because the camera picks that up. Thanks. Because of the press debacle, Shirley loses an acting job in Wisconsin. Shirley sues Danny in Wisconsin State Court. Does the court have PJ over Danny? Probably not, right?
No.
Has she suffered harm in Wisconsin? Some, right? Her rep was damaged there. It's probably damaged everywhere. Is it where the brunt of the harm is? No, the brunt of the harm would, I think, would be at home, where the entertainment industry is centered. But more fundamentally, was Danny telling a story about things that happened in where did I say, Wisconsin? In Wisconsin? No. Was his conduct aimed at Wisconsin? No. What we have here is injury occurring in the forum state. The conduct is not about the forum state, was not aimed at the citizens of the forum state. So under Calder and also under Walden, probably the better answer here would be no, there's not personal jurisdiction in Wisconsin. All right, I'm looking up at the clock, and I'm looking up here, and it says 4:58 p.m. So you guys have been troopers. It's been hot. It's been cold. It's been a long day. So everybody have a great night. Thank you very much. And you take care.